Your name, sir?
Russell Exelby.
Take your hands out your pocket.
Before we even get into the back and forth, here's what you need to know. We've got a defendant, Russell Exelby, standing in front of Judge Simpson over a bond violation tied to a SCRAM tether. That's the ankle monitor designed to detect alcohol consumption. And the alleged explanation? His socks slid under the tether while he was farming. Yes, you heard that right. Socks. Farming. Tamper alert. Now, in courtroom terms, a bond violation is serious. When someone is out on bond, parquet, they're essentially on conditional freedom. The court says, follow these rules and you stay out of jail. Break them, and that freedom can vanish fast. So when a SCRAM tether registers a tamper, meaning it thinks someone tried to interfere with it, judges don't take that lightly. What makes this explosive is the dynamic already forming. Defense suggesting an alternative monitoring system, the prosecution pushing for stricter testing, and Judge Simpson clearly skeptical from the start. And when a judge starts verbally dissecting your explanation, that's not a good sign. Watch closely. This isn't just about socks. It's about credibility. It's about whether the court believes this defendant is gaming the system. And when credibility collapses in front of a judge, consequences follow fast. Now let's see how this unfolds.
All right, what are we doing?
We need a prelim exam date, Your Honor.
You see his bond violation?
Yes. He addressed that. He went over to community corrections. He is a farmer. And he can illustrate if you want. He'll take an ETG test, whatever. But his socks slide up underneath the tether on his ankle. And he showed it to me, and yes, they do. Soberlink might be a better idea.
So what's his sock sliding under have to do with him being a farmer?
Because he's out in the field all the time.
I just, the way I work and I have to crawl under equipment to maintenance it and grease it, and the socks might move and it can get wedged between the.
I mean, he's an actual farmer. I used to think all the food you get grows at Kroger's, but it grows it on the farm.
Okay, that's nice. However, Ms. Lundy, you wanted to say something? I'm sure.
I spoke with Mr. Vincent about this earlier, and I suggested that perhaps the court may entertain a Soberlink, but I would be looking to have more than just the 2 tests that are usually done on a Soberlink. If the court's going to order one, I ask that we look at potentially more. And Mr. Vincent informed me that because the defendant's work requires him to be out in the field, he may not be able to do tests throughout the day. And I'm not sure, because this is an OWI third, I feel very uncomfortable with the defendant not testing more than twice a day on a Soberlink or being on a SCRAM. So that was going to be my request and the information I just wanted to share with the court.
So if he was put on a Soberlink, which would be a gift from me to him, you're going to tell me he can't test? Because my Soberlinks, when I put my Soberlinks on, it is 3 times a day minimum.
Can you test 3 times a day?
I would rather have this, I think.
Are you able to stop it from? You got to do something about your sock.
Okay, so hold on a second. First of all, I'm just going to let you know. The sock story, I don't believe it for a minute.
This is a pivotal courtroom moment. Judge Simpson doesn't hedge. He doesn't soften the blow. He outright says he doesn't believe the sock explanation, and that matters. In bond violation hearings, credibility is everything. There's no jury here. The judge is the fact finder. If he doesn't believe you, you're already on unstable ground. Notice what he does next. He compares this defendant to other people on SCRAM tethers who wear socks without issue. That's judicial reasoning in real time. He's evaluating whether this explanation makes logical sense based on experience. Judges see hundreds of cases. When something sounds unusual, they measure it against patterns they've observed. And here's the deeper issue. This defendant is already on an 03, a third offense. That signals repeat behavior. When someone with a history appears to tamper with alcohol monitoring, the court's tolerance shrinks dramatically. Let's be honest, do you think the sock explanation holds up? Or does it sound like damage control after getting caught? Drop your take in the comments. Because in this courtroom, skepticism is rising and the pressure is building.
And only because I've got plenty of people that are on a SCRAM tether that wear socks. And the socks don't just jump under the tether. And I don't think farmer socks are any different.
I understand. You know, I know this court, I know, Your Honor. For a long
And you
time.
know, this look on my face is one of
I
absolute
don't even
disbelief.
have to look at your face to know the look on your. I ask him point blank, you better not lie to this judge.
I'm not lying.
And he's willing to take an ETG test.
I can send him back there, and we got a guy back there that did it today.
That lied.
Oh, yeah.
I warn everybody. Everybody. Don't dance when you come in here.
Don't think you need to have a warning.
Yes, they do.
So that's why I don't believe this. I don't
He
think it's
showed
a-
it. To
I
me.
don't
I
think
just,
I
I could
know.
show that.
But Mr. Vincent, I don't think it's a sock thing. And let me just tell you how I'm putting this together in my head. I've got somebody on an OWI3 who has a tamper on a SCRAM tether, who then, when I would be potentially putting on a Soberlink, tells me he can't test and would rather have the unit that allegedly he's been tampering with.
You better want a Soberlink real bad.
That's, I mean, I don't know.
You listen to what your attorney's saying?
Yes.
You listen to what the judge saying?
I guess I'll go with the Soberlink if that's.
You want
yeah.
one more than?
Well, here's the choice. Here are the choices so that you can make an informed decision.
This is classic judicial leverage. Judge Simpson lays out two options, and they are strategically designed. Option 1, Soberlink, 4 breath tests per day. That's stricter than the standard 2. Option 2, contest the tamper allegation at a hearing, but sit in jail while you wait. Legally, this is powerful. A judge has broad discretion when it comes to bond conditions. If the court believes there's been a violation, it can increase restrictions or revoke bond entirely. The gift language the judge used earlier wasn't sarcasm, it was a signal. Soberlink is leniency compared to immediate incarceration. Now look at the defendant's reaction. He says he can't go to jail because it's harvest time and he has animals to care for. That's understandable on a human level. But legally, the court's priority is compliance, not convenience. Here's the uncomfortable truth. When someone initially resists stricter monitoring but quickly agrees once jail is mentioned, it can reinforce the judge's suspicion. If you were in his position, risk jail or submit to 4 tests a day, what would you choose? And more importantly, do you think the judge is being fair or drawing a hard line because of the 03 history?
I will be gracious enough, since counsel has talked to you, to give you a Soberlink device that you will have to blow into. Now, it will be 4 times per day that you will have to blow into. Or what you can do is you could have a hearing on this tamper, but pending the hearing on the tamper, I would be remanding you to jail. So your choice.
Yeah, no, I can't go to jail, so I guess it's the Soberlink.
Oh, no, you could go to jail.
It's harvest time. That's what he means.
Yeah, I have animals to take care of, and yeah, so I'm trying to stay out of jail.
So does that mean he'll take a Soberlink 4 times a day?
Sure. I'll even take it a couple times a day.
Yeah, but that, we know how that is. Can you get out of the order? So I'm not going to set this because I want to make sure that he's going to make it through this. I'm going to adjourn this 2 weeks out, then I'll set the prelim,
Okay.
but I'm not setting it. Well, so I'm signing the order. You're to go over and be placed on a Soberlink device. Where do we put it in? Oh, we did it. Okay. You just throw on there, tether can be removed, or SCRAM tether can be removed. Oh, I need to file. So I'll adjourn this out to November 21st, probable cause conference. 9 a.m. You'll be on the Soberlink, no miss test. Bond will otherwise continue. Thank you.
Appreciate that. He does. I'm going to explain to him how much he appreciates you.
Thank you.
Meet me out in the hallway.
Good morning again, Your Honor. Brian Bowling on behalf of Mr. Hamby. State your name for the record.
Joshua Hamby.
Judge, we're asking for an adjournment. Ms.
course you
I have
Go ahead.
closed. I'm sorry?
No, never mind.
Oh.
Here's Mr.
We're close to a resolution.
What?
We're close to a resolution. We just need a little more time.
You need it?
If I may, Judge. I love your videos on YouTube. I just wanted to tell you, you're doing a wonderful job. I'll be watching it. You're awesome, dude. When I see your face walk out of here, I was like, you serious, right?
Well,
And just like that, the tone shifts. We move from tense bond violation drama to a defendant complimenting the judge's YouTube presence. This is one of those surreal modern courtroom moments. Judges today are increasingly public-facing, educational videos, transparency efforts, and occasionally defendants recognize them. But here's the subtle dynamic. Flattery in a courtroom can be risky, while Judge Simpson handles it professionally, thanking him. Keeping it moving, courts are not fan meet and greets. They are formal proceedings with serious stakes. This second case appears to be heading toward a potential resolution, which is why the adjournment request is routine. An adjournment simply means postponing the case to allow more time for negotiation or evidence review. Nothing dramatic there. Still, moments like this humanize the courtroom. You see personality, you see real reactions, and sometimes, that can lower tension before things escalate again. Do you think complimenting a judge in open court is smart strategy or unnecessary risk? Because what happens next proves that not every defendant leaves the courtroom on a smooth note.
thank you, sir.
Yes, sir.
All right. How much time did you need, Gun? Couple weeks?
I think 2 weeks should be sufficient.
All right, very good. Probable cause conference, November 21st, 2024, 9 a.m. Bond will continue. Again, thank you for your kind words.
Appreciate you, Judge.
Thank you, Your Honor.
Keep kicking butt, Judge.
I'll take that as a legal phrase. All right. Court does call the case, People versus Brandon Ham.
One Brown, Deputy Chief Public Defender, Ben Rendered on behalf. Did you have a chance?
Shorter leave, talking to.
I would like to get you talk to her.
Hello, Your Honor.
Hello.
We are asking for an adjournment, as you probably saw in your file. We have some discovery to receive in this case and go over with my client.
Your name, sir?
Brandon Hampton.
How much time are you going to need, counsel?
2 weeks, Your Honor.
Probable cause conference, November 21st, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Oh, no, go get him. Let's get him.
Your Honor, may I approach?
Sure.
As well as.
Yeah.
You have to hit OK in the middle of the screen.
Go.
This guy is refusing to be seen downstairs, and this facility never signed in.
Okay.
Court recalls case People versus Brandon Hampton. Mr. Hampton, what's wrong with you and why'd you do that on your way out? All right, counsel, here's what I'm going to do. Mr. Hampton, that behavior is not going to be tolerated in my courtroom. At this point, I'm revoking defendant's bond. Defendant is remanded to the Washtenaw County Jail. I'll move his hearing up to next week, November 14, 2024 at 9 a.m. You may take it.
This escalated fast. Brandon Hampton exits the courtroom, does something disruptive on the way out, and immediately the judge recalls the case. That's critical. When a defendant misbehaves in or around the courtroom, the judge has direct authority to act instantly. Bond revocation is serious. It means the court has decided that the defendant can no longer be trusted to remain free under conditions. The judge cites behavior in the courtroom itself, not new charges, not missed tests, but conduct that signals disrespect or instability. Judges maintain order not just for decorum, but for safety and authority. When someone undermines that, consequences are swift. Legally, this shows how fragile bond status is. You can be compliant 1 minute and remanded the next if your behavior crosses a line. Was this an overreaction or a necessary show of authority? Because from a judicial standpoint, allowing visible defiance to go unchecked can weaken the entire courtroom structure. And just like that, he's headed to jail.
Approach.
Let's break down what we just witnessed. In the first case, Russell Exelby faced a bond violation tied to an alleged SCRAM tether tamper. Judge Simpson made it clear he did not believe the SOC explanation. Instead of immediate jail, the court imposed a stricter monitoring condition. Soberlink testing 4 times per day. That's judicial discretion in action, balancing accountability with an opportunity to remain free under tighter supervision. In the second and third cases, routine adjournments were granted as attorneys worked toward potential resolutions. Nothing extraordinary, just standard procedural continuations. But then came Brandon Hampton. A moment of inappropriate behavior outside the courtroom led to immediate bond revocation. That decision underscores a broader legal principle. Bond is conditional liberty. It can be revoked not just for new crimes, but for conduct that demonstrates disregard for court authority. The takeaway? Credibility and courtroom behavior matter. Judges evaluate not only evidence, but attitude and compliance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.